Good day everyone, we are Group 3, but we basically assign in 5th of this topic lessons that we are going to discuss today. And this is the Module 6, General Provisions of Contracts under the Law Article 1305 to 1317. Let's start by assessing whether the lessons this video presentation seeks to impart are those we actually should learn. But for now, let's proceed first to the overview of this topic. You are now on the second part of the law on obligation of contract. After a truth understanding of the concept and nature of obligations, it's now time for you to gain understanding on the basic concepts of contracts, its elements, life stages, characteristics, and applicable provisions of law governing such. Contract is one of the sources of obligation. Contract is the cause, while obligation is the effect. The manner by which the obligation is to be executed depends on the stipulations in the contract. A business student like you has to be familiarized with the different elements, classifications, and characteristics of a contract, as you will deal in one way or another with contracts when you enter into different business transactions. This module will give you an overview of the general provisions of contracts based on the Article 1305 to 1317. Knowledge on this subject matter will be important to you, so that you will be able to comprehend the succeeding topics on contracts. Illustrative examples as well as legal opinions were also included in this module so that you will be guided on how to make decisions on cases involving general provisions of contracts. Let's start, learn, and grow in knowledge together. In the learning objectives, at the end of this lesson, we the students are expected to understand the concept of contract, identify the elements, classifications, stages of life, and characteristics of contracts, decide on cases involving different characteristics of contracts. And this module had our 5 topics that we are going to discuss. The first is, what is a contract or the meaning of a contract? The second is, what are the elements of a contract? The third is, what are the classifications of contract? The fourth is, what are the stages in the life of a contract? And lastly, what are the characteristics of a contract? Now that we already knew about the overview of this lesson, let's continue by giving a definition on what a contract really is. Based on Article 1305, a contract is a meeting of minds between two persons whereby one binds himself, with respect to the other, to give something or to render some service. A contract was an agreement between the two parties that was enforceable by the law. This means that a contract was an agreement and consisting of the reciprocal promises between two parties. In the case of contracts, the two parties are legally bound by the agreement made by them. This was only enforceable when the requirements needed were satisfied by the applicable law. To make an agreement which results in a contract, there must be an offer and an acceptance. And to the promises which stem from the offer and acceptance, the law attaches a binding force of obligation. Hence, contract can be defined an agreement enforceable by the law between two or more parties to do or to abstain from doing some act or acts, their intention being to create legal relation and not merely to exchange mutual both having given something or having promised to give something of value as consideration for any benefit derived from the agreement. Contracts are not only applicable to business but are also part of our everyday life. A contract is made out of the simplest act of purchasing, like buying a newspaper, using a credit card to buy a dress, or paying a parking fee. Other contracts such as the sale and purchase of property are more complex, requiring formal documents that have written documents. Contracts forms the basis in many transactions, for instance the buying and selling of goods and services, employment contracts, partnership contracts, and insurance policies. The formation of a contract is based on obligations that are freely assumed rather than imposed. The liability in contract is based on voluntary undertaking of the obligations by the individual, such as the law assumes that the parties are free to make a contract any way they wish, based on the concept of freedom and equality. In making the bargains, the parties by equal position, the obligation imposed under a contract is self-imposed, entered freely by the parties. The law is only concerned with the fulfillment of certain conditions by the parties so that the transaction can be recognized as a legally binding agreement and enforceable by law. Malaysian contract law is embodied in Contracts Act 1950, which is based on the English law of contract. However, it should be noted that there are other statutes which may impact contractual transactions. Government Contracts Act 1949, English law relating to contracts, is applicable in relation to areas not covered by Malaysian legislation or Malaysian Case Law Section 3 and Section 5 Civil Law Act 1956. Agreements without considerations are also void. An agreement which imposed any restrictions on marriage and an agreement that imposed any restrictions on trade. According to Section 2 of the Indian Contract Act 1872, an agreement which is not enforceable by the law at adoption of one party and not at the option of other than that agreement is voidable. In a voidable contract, one party can be bound by the contract terms while the other party has the right to change their mind. If the agreement is made without the free consent of one party, then that person can avoid the contract. If such a party does not avoid the contract, then the contract remains valid. But if the party prefers to avoid the contract, then the contract will become void. For example, if the consent is obtained by following ways, the contract will be considered as voidable at the party whose consent is obtained so by coercion, fraud, undue influence, or misrepresentation. Void contracts are valid when they are entered into as they conform to all the conditions of enforceability laid down under Section 10 of the Act and are binding on the parties, but later on becomes void because of impossibility to perform. There are also a lot of reasons why a contract cannot be enforceable anymore in the eyes of law because such contracts becomes unenforceable in the eyes of law due to supervising impossibility, change of law, subsequent illegality, repudiation of voidable contract, contingent contract, etc. The main difference between the two contracts is that a void contract cannot be performed under the law, but a voidable contract can still be performed. Until it is avoided by one party, with a void contract, it's invalid from the very beginning. It doesn't require one party to back out or challenge its validity. In this case, neither party can enforce a void contract since it's viewed as though the contract never existed. With a voidable contract, it doesn't become invalid until one party asserts a legal reason for cancelling or revoking it. This means, without one party raising a legal objection, the contract would remain valid. A contract or obligation may occur on following ways: by agreement and contract, by standard form contract, and promissory estoppel. And now that we basically already know about contracts, let us now identify the elements of a contract. The first major element of contract was the essential element. Essential element was the elements without which there can be no valid contract. These elements are consent, object or subject matter, and cause or consideration. It has three major parts: the consent, object, and cause. The first was the consent. Consent was free and given by someone who is sui juris, or one who has capacity to act. Therefore, it must be freely given by the party, and must be an intelligent consent. The party must know what he is consenting for. This is giving one's conformity to the terms voluntarily. It is the concurrence of the minds of the parties on the cause and subject matter which will constitute the contract. As well as on the other conditions and terms, there will be an action which they voluntarily bind themselves to comply with. Consent may be expressly or implied. The second one was the natural element. Natural elements are those elements which are found in a contract by its nature and presumed by law to exist, such as warranty of hidden defects or eviction in contract of sale. This element is a warranty for the defects or eviction of a certain contract of sale that will be presumed by the existing law. It is also presumed to exist in certain contracts unless the contrary is expressed as stipulated by the parties. And the third one was the accidental elements. This element exists by virtue of an agreement for the purpose of expanding, limiting, or modifying a contract. Such accidental elements are conditions, clauses, terms, modes of payment, or penalties. It is also the particular stipulations, clauses, terms, or conditions established by the parties in their contracts. After we learn about the nature and the elements of contracts, let us now study about the classifications of contracts. There are three types of classifications according to this tree. The first one was according to perfection. This classification was indicated as the manual contract that binds both contracting parties. One person must have a definite offer and the other must have an absolute acceptance of the offer. and the first was the consensual. This classification was perfected by the perfected consent, object, and cause, or COC. Example, sales, partnership, and real mortgage. These variables are one of the factors that affect the consensual contract. Sometimes a consensual contract that is based on the purely unanimous consent of the interested parties and does not have to be implemented by formal procedure. So, if you guys remember, ito yung mga essential elements ng contract. The second one was the real contracts. This contract was one requiring that something should be transferred from one party to the other and that the obligation arising should be for the return of that thing. Real contracts included loans of money, loans of goods, deposits, and pledges. Therefore, hindi sapat sa mga kontratang ito na magkaroon lamang tayo ng mga essential elements which include the consent, object, and cause. So, ang contract's object at prestation ng kontrata ay dapat ding ma-fulfilled. And the third one in this classification according to perfection was the formal or the solemn contract. It is a contract where both parties have signed under seal. A seal can be any impression made upon the document by the parties to the contract. This was traditionally done in wax stating the intentions of the parties to be bound by the contract. So kapag sinabing formal contract are those that are perfected by consent, object, and cause, together along with formalities required by law. Dapat tayong sumunod sa mga legal na formalidad na inaatas ng batas, in addition to having sufficient consent, object, and cause. The second classification was according to another contract. This type means that any agreement entered into between the contractor and the city that is formed under the authority of MCC for the purchase, sale, or lease of real or personal property, or for materials, supplies, equipment, or services which are approved and or authorized by the City Council. The first in this type was the principal contract, which is a type of contract where the contractor has control over the construction phase of a project involving more than one contractor. They are appointed in writing by the client to plan, manage, monitor, and coordinate health and safety during this phase. The second one was the accessory contract. This contract was a one made for assuring the performance of a prior contract, either by the same parties or by others, such as suretyship, mortgages, and pledges. And the third one was the preparatory. This contract is an agreement that is in anticipation of another subsequent contract that will supersede the terms of the earlier contract. In essence, the earlier contract is a commitment directly related to the formalization of a future agreement. And the last type of the contract was according to the parties oblig. This kind of contract refers to the legal duty of contracting parties to fulfill the promises specified in their contracts. If the obligations of a contract are in question, a person's reasonable capacity to perform or refrain from performing the required task will be taken into consideration. The first type of this contract was the unilateral. This type was an express offer that payment is made only by a party's performance. Another example of unilateral contract is a reward or a contest. In a unilateral contract, the offeror may revoke the offer before the offer's performance begins. And the last type of contracts was the bilateral contract. This type of contract is a binding agreement between two parties where both exchange promises to perform and fulfill one side of a bargain. This type is one of the most common binding agreements used because it turns both parties into what is known as an obligor. In other words, a person or party that is bound to another.
According to name or designation. When we say name, we have the nominate and innominate contract. Kapag sinabi natin na nominate contract, the law give it a special name or designation. So, eto po yung mga example. Actually, lahat po ng mga nabanggit kanina na example, lahat yun ay nominate contract kasi may pangalan. So, ito po yung mga example. Sales, loan, partnership, donation, and lahat ng nabanggit ko ay basta meron siyang pangalan under the law, they are considered our nominate contract. Kumbaga, merong rule. Meron tayong pagtitingnan ng guidelines kung ano bang meron sa specific contract na ito. So, however naman, in-nominate contracts are not named under the law. So, the law does not give it special name or designation. Pero in this slide, we classified it into 4. So, first, do ut des, do ut facias, patio ut facias, and patio ut des. So, ang English translation ng mga ito ay I give that you may give, I give that you may do, I do that you may do, and I do that you may give. So, these are the 4 classification of innominate contract. So, when dealing with innominate contracts, so, inuulit natin, ang pagkakaiba kasi ng nominate contract at innominate contract, yung mga nominate contract, meron silang rules under the law. Mababasa, specifically civil code. Itong mga to, sales, loans, partnership, donation, mababasa sila under the civil code. May mga certain guides doon na makikita nyo. Kumbaga, when dealing with certain circumstances, alam natin yung gagawin natin kasi merong guideline by the law. However, innominate contract ay walang guidelines ito. Pero ang sabi dito sa Article 1307, when dealing innominate contract, ito yung mga susundan natin. Ganito po, number 1. Itong nominate contract na ito, may stipulation ba yung parties natin? So, syempre, masusunod. Actually, in order of priority, number 1, masusunod kung ano yung merong, kung ano man yung na-stipulate ng mga parties doon. Kung gusto nila na ganito, ganyan, masusunod yun as long as hindi siya bawal or hindi siya pinagbabawal sa batas. Hindi siya against sa moral. Hindi siya against sa public order, public policy, and good custom, di ba? So, okay lang siya. Okay, masusunod yung mga stipulation ng mga parties. However po, kung hindi masyado malinaw yung stipulation ng mga parties, punta tayo sa number 2. Rules governing law on obligation and contracts. Pero kung minsan kasi, yung mismong obligation and contract, medyo naka-generalize. It refers to all kinds of contract. So, naka-generalize siya mga yan. Kapag hindi pa rin natin kumbaga, hindi pa rin natin siya maintindihan or ma-deal with the number 2, yung mga nabasa natin under obligation and contract, punta tayo sa number 3, which is rules governing the most analogous contract. So, kung yung in-nominate contract ay mukhang sales, we bring the rules governing law on sales kasi yun yung most analogous. Kapag sinabi kasi nating most analogous, parang iyon yung pinakahawig niyang contract. So, although para siyang contracts of sales, pero hindi siya talaga sales kasi hindi niya na-meet yung definition or requisite ng isang sale contract of sale. Pero pwedeng gamitin yung rules on contract of sales para dun sa in-nominate contract. And lastly, paano kung walang analogous contract na pwedeng mag-deal with that in-nominate contract? So, we referred to number 4. The custom of the place. Or kung ano ang nakagawian sa lugar na yon. Yun na ang susundin. So, ito, yung rules natin when dealing with in-nominate contracts that are, or contracts that are not named under the law. So, next, we have our 5th classification according to risk. We have commutative and aleatory. So, first is commutative, when the undertaking of one party is considered the equivalent of that of the other. For example, in a contract of sale, yung binibigay ng seller and then the buyer sa bawat isa ay considered of equivalent value. So, for example, yung binayad ni buyer, yun yung per market value or yun yung price, and usually, that is per market value nung specific thing na yon. Ganon din, diba? So, nagkakaroon ng equivalent exchange. So, ganun din yung contract of lease. Nagkakaroon dito ng equivalent exchange. However, in aleatory contract, hindi sigurado or it depends upon an uncertain event kung ano ang marireceive ng both parties. For example, in a contract of insurance, yung nagpapa-insure, nagbabayad siya ng premium. Fiction. However, yung nare-receive niya na benefit, it depends upon an uncertain event. Kapag nangyari, so medyo may malaki-laki siya na matatanggap compared doon sa binayad niyang premium. However, kung hindi nangyari yung sa condition natin and contract of insurance, ayun, lugi siya. So, may certain amount din siyang mare-receive. Siguro depende yan sa provision ng contract of insurance. Meron din tayong sale of hope. So, for example, bumili kayo ng lotto tickets. Fix yung amount ng lotto ticket, 20 pesos. Pero it's either you will receive zero or a certain amount beyond or millions kung naka-jackpot ka. So, yun yung aleatory contract. So, next, number 6. We have according to cost. Kung maaalala nyo, yung cost is one of the essential elements. Consents, object, and cost. Ano nga ba yung cost? Onerous, gratuitous, and remuneratory. In onerous contract, the cost has a valuable consideration. For example, ganito, in a contract of sales, the object is the kung ano yung binebenta at yung cost ay yung price nung binebenta. So, yung price nung binebenta has a valuable consideration. Kasi, usually, it will be paid in money. So, next in gratuitous contract. Ito naman, the cost is purely generosity. Walang valuable consideration masyado. Okay, so, yung comodatum is gratuitous contract. Ang object under a comodatum is kung ano yung bagay na ipapahiram mo. However, ano ang cost nun? It's purely generosity. Ang cost nun is pinahiram mo. So, walang valuable dun sa cost. Ganon din sa donation. Kapag ipinahiram mo ang isang bagay, wala kang matatanggap na valuable consideration. Ang cost nun is purely generosity or the liberality of the kung sino yung nagdo-donate or nagpapahiram in case of comodatum. Letter C naman, remuneratory contract. The cost is based on services or benefits already received. So, for example, in a contract of employment, kapag nakapag-render na yung employee ng kanyang services, so, that's the cost of hour na ibibigay ng remuneration or yung salary niya. Next, last classification na itatakal natin dito ay according to binding force. So, when we say binding force, gaano ka ba mababind sa contract na ito? So, actually, naka-arrange tong mga to from the most binding, letter A, and the least binding or no binding at all. Actually, void contract, not binding at all. So, those are classification of contract. Now, let's move on to the stages of a contract. So, ano yung mga different stages ng contract? Number 1, we have preparation, conception, generation, negotiation. So, yan yung mga sa number 1, actually, wala pa tayong contract. So, nagkakaroon lang tayo ng kontrata dito sa number 2, which is the perfection, birth, or formation. Usually, ang ginagawa lang sa number 1, nag-uusap pa lang yung dalawang parties kung ano ang magiging stipulation dun sa contract. Usually, yun yung kapag dinadrop pa lang yung contract. Kung ano ang magiging consequence kapag hindi sumunod. Kung ano yung magiging benefit nila from the contract. So, number 2, usually, yan yung kapag pinirmahan na ng dalawang parties yung contract. Pero take note, ang contract pwedeng hindi siya in paper. Ang contract, necessarily, pinipirmahan yan. So, next, number 3, we have consummation, death, or extinguishment. Pagdating dito sa number 3, lahat ng obligation within the contracts, napulpil na. Nagawa na natin lahat. So, ang main point lang natin dito ay kailan nagkakaroon ng contract si number 2.
We have the different characteristic of a contract. Ito ay ang mutuality, autonomy, relativity, consensuality, and lastly, obligation, force, and compliance in good faith. Now, I will explain the first characteristic of a contract, which is mutuality. Mutuality is the agreement must be binding on both parties. Ibig sabihin nito ay when two parties are involved sa isang contract ay hindi dapat na yung validity ng contract or compliance ay nakadepend on a single person. Because when we say mutual, ito ay pinagkakasunduan ng two parties. Hindi ito magiging valid kung ito ay magre-rest lamang to a one person. A contract of adhesion is a standard form contract, often called a boilerplate contract, na kung saan yung isang partido ay may nakahanda ng kontrata without input from the sign. Halimbawa, naghahanap ka ng apartment and you talk the apartment owner at meron siyang ginawang agreement form and yung mga nakapaloob doon is yung mga pinagbabawal sa apartment and the owner tells you that the agreement cannot be changed and you can take the apartment or leave it. Based in Article 1309, if ever the two parties ay di magkasundo, pwedeng ibigay ng determination ng validity or compliance ng specific as stipulation na yung within the contract to a third person. But even if you give it to a third person to decide kung anong magiging stipulation or magiging itsura ng contract, kailangan ng third person na i-communicate pa rin ito sa dalawang parties. At dapat ultimately ay mapagkasunduan ng dalawang parties dahil kung hindi, ito ay hindi pa rin magiging valid. And according naman sa Article 1310, kung sakali na di pa rin magkasundo ang dalawang parties, they can go to court and then determine ang kung ano yung magiging equitable. Illustrative example. Joshua sold his parcel of land to Caleb. It was agreed that Cain, a real estate appraiser, would be one to determine the reasonable price of the land. Cain then fixed the price after considering all the circumstances and factors affecting the value of the land. Legal opinion. In this case, the price fixed by Cain will not be valid until both Joshua and Caleb agreed to the set price. Cain must first communicate to both parties his appraisal, and the decision whether to adopt it or not will depend on both parties. The validity of the contract must be based on the mutual consent of both parties. Dito sa example, si Joshua and Caleb ay hindi magkasundo sa magiging price ng lupa. Kasi si Joshua, although siya yung nagbebenta ng lupa, hindi rin kasi niya alam kung paano mag-price ng tama, kung ito ba ay mataas or ikakalugi niya. Kaya ang ginawa ni Joshua at Caleb para hindi isa lang ang magde-decide sa kanila, sila ay nag-hire ng third person which is si Cain. Si Cain ay isang expert sa pag-appraise ng mga ganyang situation. According to Article 1309, once na nag-appraise ni Cain yung land at nagbigay siya ng amount, example ay 5.1 million. Hindi ibig sabihin ay binding na agad yon dahil kailangan i-communicate niya muna ito kay Joshua at Caleb at ultimately magde-decide pa rin sila at kung magkakasundo sila sa price na iyon. According naman sa Article 1310, kung sa palagay naman ni Joshua nalugi siya, pwede naman itong dalhin sa korte para malaman kung ano ba ang magiging equitable para sa kanila. The two characteristics of a contract is autonomy, also called liberty of contract or freedom stipulated in contract. According to Article 1306, ay sinasabing nagbabase ito sa contract ng different parties. ini-establish sa tulong ng stipulation. At ang stipulation ay general term for an agreement, bargain, provision, or condition. May mga iba't ibang condition kasi tayong kinoconsider pag-usapan ay kontrata. At ang stipulation will be binding if it complies with an applicable statute or court rule. A stipulation is a fact, promise, or provision in a contract that is agreed upon by two parties. Clauses, at ano nga ba ang ibig sabihin nito? Ito ay specific provision or point in a law or legal document. It can be an article, section, or standalone paragraph that addresses any topic related to the documents. Term and condition indicate din dito sapagkat ito ay law. Sa lahat ng gagawing batas or pagsasaayos ng isang batas, kailangan nating sundin mabuti ang iba't ibang terms and condition na nakalahad. Maaaring dapat natin ito sundin para hindi ma-disqualify ang ating pinaghirapan. Meron tayong sinusunod na iba't ibang condition na maaaring makatulong sa ginagawa nating pag-aaral about sa batas na kailangan nating isaayos or isagawa or sa ating inaayos na kontrata. Mas mabuting sundin ang iba't ibang terms and condition na nakalahad para sa mabilis na pagpuproseso ng ating isinasagawa. The third characteristic of a contract is relativity. According to Article 1311, sinasabi sa relativity, ang kontrata ay nag-e-exist lang between sa parties. Ibig sabihin, anuman ang benefits or consequences ng kontrata ay involved dun ang dalawang parties na iyon or yung mga naka-assign nila or heirs in case na may mawala o mamatay sa dalawang parties, sasaluhin nila yung utang nung descendant. Contract take effect between the parties in the contract with exemption. Sa isang kontrata, kung ano lang yung nakapaloob doon at kung sino lang yung mga taong nakasama, ayun lang ang makikinabang. Halimbawa, sa isang pamilya, may pinirmahan o ginawang kontrata para sa distribution ng mga ari-arian. Tas kung sino lang yung nandun, ayun lang yung makikinabang. Contract are generally transmissible except law, stipulation, nature. The right and obligation are transmissible because they are only binding between the contracting parties if they are not. When the right of obligation is personal to the party, assigns and heirs are not permitted. He is not liable beyond the value of the property he received from the descendant. Example dito is may mother kang may utang na 400k. Ang nangyari ay namatay ang mother mo. So, nag-iwan ng pamana sa'yo ng 300k yung mother mo. So, yung utang ng mother mo ay namana mo or napasa sa'yo. Pero dahil 400k ang utang at ang minana mo lamang ay 300k, ikaw ay lugi. Kung ikaw ay sisingilin ng kanyang creditor, ang obligation mo lang bayaran doon ay yung up to extent na na-receive mong property from your parent. We have 4 exemptions in relativity contracts. Una, stipulation for outre. Article 1311. Simple definition of stipulation for outre grants the third party beneficiary a claim for specific performance against the promisor. Ang pangalawa naman ay ang third person in possession creating real rights. Article 1312. Under to Article 1312, contracts creating real rights, third person who come into possession of the object of the contract are voluntarily subject to the provision of the mortgage law and the land registration law.
As previously discussed, relativity of contracts take effect only between the parties in their assigns and heirs. However, there are exceptions for that rule. One of them is stipulation pour autrui, based on Article 1311, Paragraph 2. So, what is stipulation pour autrui? Let's start off by dissecting and learning each of its words. First, we have stipulation, which means condition or requirement that is specified or demanded as part of an agreement. It is pretty self-explanatory. It's a specific demand on an agreement. Next, we have pour autrui. Literally translated from French, it means for others. So, with just this, we can already get a bit of a grasp of what stipulation pour autrui is. A specific demand in an agreement that includes other persons. Stipulation pour autrui is an exception to relativity of contracts. Since third persons do not participate in the negotiation or preparation of contracts, they cannot be bound by any agreement entered into such contracts, unless the third persons give their consents or accept any benefit accruing from such contracts. Stipulation pour autrui is a direct conferment of a benefit towards a third person. So, because we are on the stipulation pour autrui, it means that this third person could acquire the benefits from the contract. The requisites are: letter A, there must be a stipulation in favor of a third person. So, there must be a demand or condition in the contract in favor of a third person. Letter B, the stipulation must be part, not the whole of the contract. Letter C, the contracting parties must have clearly and deliberately conferred a favor upon a third person, not a mere incidental benefit or interest. Letter D, the third person must have communicated his acceptance to the obligor before its revocation. The consent of the third person before the revocation is important. Letter E, no relation of agency exists between any of the parties and the third person favored. Let's have an example. Peter is indebted to John for 100,000 pesos with 10% interest. It was stipulated that Luke will receive 10% of the interest. The stipulation is accepted by Luke and duly communicated the acceptance to Peter and John. After a year, Peter and John decided to change the contract into giving a specific house and lot. So the legal opinion is, under relativity of contracts, the third person cannot act upon the decision of both parties in a contract. However, Luke in this case is an exception, since he is a party interested in the fulfillment of the contract, as he should be receiving the 10% interest. He may insist his right of receiving the 10% interest despite of novation. Alright, next we have third person in possession of a property creating real rights. So, what does this mean? Let's have an example so we can understand it further. Abraham sold to Jacob a specific land for 500,000 pesos. Jacob occupied the said land but did not register it. One day, Abraham sold the same land to Isaac. Isaac registered the said property at the Registry of Deeds. So the legal opinion is, between the two, Jacob and Isaac, who are claiming to be the owners of the specific land, Isaac has a more preferred rights over the land as he registered the title of the land in the Registry of Deeds. Isaac has a real right over the land since he is in possession of the title of the land. He may actually evict Jacob from the land, assuming that Isaac is not knowledgeable of the previous transaction of Abraham and Jacob and bought the land in good faith. Jacob may go after Abraham for the reimbursement of his payment and claim for damages.
The third exception is when a contract is entered to defraud creditors. Illustrative example: Maria is indebted to Martha for 100,000 pesos. Maria, fearing that he will not be able to pay the debt and ultimately his land being leveled, she sold the said land at a very low price to Ruth with the condition that he can purchase it back. The main contract natin dito ay between Maria and Ruth. So sabi natin, under relativity of contract, contract must take effect only between the parties involved the contract. It means yung contract ay nag-exist lang sa dalawa na iyon. Kahit anong matatamasang benefits or pananagutan, consequence, yung parties na involved at kung may heirs or successor sila ang makakakuha or makakatamasa nun. However, in this case, according to the exceptions of relativity of contract, pwedeng makisali yung third person, which is si Martha. Dahil si Martha yung creditor na defraud sa ginawang act ni Ruth. Maybe in the first place, ay very interested na si Martha sa lupa ni Ruth. Pero hindi nga pinagbebenta ni Ruth yung lupa, kaya naging parang collateral na lang yung lupa if ever na hindi makabayad si Ruth ng 100,000 pesos kay Martha. Third person induce a party to a contract to violate the contract. Illustrative example: after agreeing to sell his parcel of land to Joel, Amos sell the land to Noe instead because of the inducement of Abraham. The main contract natin dito ay between Amos and Joel, regards of the sale of land. But ang nangyari sa case na ito ay hindi nag-comply si Amos kay Joel because of the inducement of Abraham. In this case, ito yung sinasabi natin na hindi lang benefits yung maaari nating matamasa, kundi pati na rin yung consequence for violating the contract. Diba hindi nag-comply si Amos kay Joel? So dapat ang issue or kasuhan ni Joel ay si Amos for not doing their obligation. But under the exceptions of relativity of contract, pwede na nating kasuhan yung third person na nag-induce kay Amos to not comply the obligation. Because according to Article 1314, any third person who induces another to violate his contract shall be liable for damages to the other contracting party. So dito, pwedeng madamay yung third party, which is pwedeng kasuhan ni Joel si Abraham for damages. So this is the last exceptions of relativity of contract. Consensuality of contract. This is the fourth characteristic of contract. According to Article 1315, contracts are perfected by mere consent. And from the moment the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all consequences which, according to their nature, may be in keeping with good faith, usage, and law. So generally, ito yung contract which is perfected by COC. Ano yung COC? The consent, object, and cause. Di ba nasabi sa una, ang COC ay ang essential elements. So ano yung exception ng consensuality of contract? Is yung real and formal contract, wherein real contract is the addition of delivery sa COC. And yung formal contract is addition of formalities required by law sa COC. And according to Article 1316, real contract such as deposit, pledge, and comodatum are not perfected until the delivery of obligation. Perfections of real contract is not perfected by mere consent. The delivery of the things is required. Delivery is demanded, neither arbitrary or formalistic. The last characteristic of contract is obligatory force and compliance in a good faith. According to Article 1305, the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. And according to Article 1159, obligation arising from contracts have the force of the law between the contracting parties and should be complied with a good faith. So when we say obligatory force, kapag ikaw ay pumasok sa isang contract, bind ka na doon. Kailangan mo nang mag-comply or gawin yung mga obligation mo kasi force ka na ng law. Kasi pag hindi mo ginawa, may pananagutan ka na sa batas. At dapat, pag nag-complied ka sa obligation mo, dapat maayos, walang halong panloloko or pandaraya. Summary. A contract is a meeting of minds between two persons whereby one binds himself with respect to give something or to render some service. Contracts are classified according to perfection, to relation to another contract, parties obliged, name, risk, cause, and binding force. Preparations, conceptions, generations, and negotiations. Perfection, birth, formation, growth, and consummations, death, termination, extinguishment are the three stages in life of contract. The 5 characteristics of contract are mutually, autonomy, relatively, consensually, and obligatory force and compliance in a good faith.
And this is the end of our discussion. We do hope that we give you an overview and a new knowledge about contracts and the functions of it. We also hope that this report can help you grow your knowledge and enhance it better. Again, thank you all for listening to our discussion about this topic.